Arbor One West versus Jack. Is it Wazorek?
We did that last time.
Yeah, no, I'll get it eventually, but then by that time the case will be done. Come on up.
Everybody does. Everybody messes up.
Morning, Your Honor. Cheryl
All right,
Walkup on behalf of the plaintiffs.
The moment this hearing begins, you can already sense the tension in the room. On one side, we have Arbor One West, the landlord pushing hard for possession of the property. On the other, Jack, the tenant, fighting to defend his home of 6.5 years. The stakes, more than just rent or repairs. This case involves accusations of bedbugs, sanitation problems, and even claims of denied access to inspectors. But underneath it all lies a much bigger issue. Credibility. Who's telling the truth here? Jack insists the landlord never followed through on inspections, while the landlord's side argues the tenant created unsafe living conditions that threaten other residents. These contradictions set the stage for an explosive courtroom battle. Stay locked in, because Judge Simpson doesn't tolerate excuses, and you'll see him lay down the law in ways that may surprise you.
State your name, sir.
Jack Wazorek.
Okay. And where are we on this? Was this his motion?
Your Honor, I don't think he can argue the motion. There was a motion filed that was drafted clearly by legal aid, but signed by Mr. Wazorek. This was a health hazard due to bed bugs and roaches and the landlord not being able to access the premises and the premises not being available denying entry and not being prepped. We took a default judgment, and I know Your Honor wanted to review this, and that's where we were last week. It's landlord's position. Go ahead.
Go ahead.
I was just say it's landlord's position. We want possession of the premises. We've had chronic issues with housekeeping, cleanliness. It's not fair to the other residents. This is an ongoing problem.
The landlord's attorney wastes no time framing this as a community issue. Notice how quickly the argument shifts from one unit's alleged problems to the broader impact on all tenants. That's a smart legal move. Courts often side with landlords when public health and safety are at risk. But here's the catch. The law also requires landlords to provide reasonable notice and follow procedure. Did Arbor One do that? Jack says no. He claims inspections were passed and the so-called garbage bags were just pots and pans. This raises a critical question for you, the viewer. Where should the line be drawn between clutter and a genuine health hazard? And even more importantly, if Jack passed inspections twice, why is the landlord so determined to evict him now? Drop your thoughts in the comments. Is this about safety, or is there something deeper going on?
I'm very willing and ready to argue that Park Forest does not apply to a health hazard. So I'm going to leave it to you what you want to hear, but I am strongly requesting a judgment here to stand.
Sir, go ahead.
Your Honor, I have had RPI in there twice inspecting my place. They never came in.
They being who?
Arbor One.
Okay.
Never came in. Wendy, the assistant manager, I told her that wasn't a problem. The garbage bags, like I told you last week, were not garbage. They described them as garbage. Those were pots and pans and stuff we had to put in the bags because they wanted to do a cockroach inspection. 6.5 years, I've never seen a cockroach. They turned it into, well, it's garbage. There's garbage all over the house. They never brought anybody in. I had paid a lady, a friend of mine, $100 after that to come in and make sure everything was in line. You got an affidavit from legal aid showing that RPI had been in there twice and gave me a pass inspection. They passed me twice. Arbor One has never come in to my house. Wendy told me she got the report on a Friday. She said she'd have somebody in there Monday. Nobody ever showed up at all to do an inspection at all. I had to call RPI when I got the court judgment and bring them in on it.
Jack's testimony paints a picture of frustration and neglect. He claims he's been left waiting, promises broken, maintenance ignored for over 6 years. His defense strategy is clear. If the landlord failed to do their part, then any blame about infestations or clutter shouldn't fall solely on him. But here's where things get tricky. Courts don't care about back and forth finger pointing. They look at one central question: did the landlord have legal grounds to claim health hazards and deny continued tenancy? Judge Simpson is already probing whether Jack actually allowed access for treatment, and that's the key legal pivot. Even if Jack is right about inspections being delayed, denying entry even once can legally justify eviction in many jurisdictions. Do you think Jack is stalling here, or genuinely trying to defend his home?
Which I told Arbor One, I told the assistant manager, Wendy, I wouldn't get Arbor One into it if we could help it. She wouldn't let it go. I've been having problems with maintenance in there since 6.5 years. I've been having problems with maintenance. All I'm trying to do is keep a good place. RBI come in there twice. They said the inspection passed inspection. So they never come in. Arbor One never came in and did any kind of inspection at all.
Your Honor, if I may just respond to this. First of all, I don't know what affidavit Mr. Wozorek is talking about. Second of all, we're talking apples and oranges here. We're not talking about RPI. We're talking about bed bugs. We're talking about the treatment provider came to the unit on 2/2, was denied access, and then
But
came
that
back
wasn't
of the
that
hearing.
wasn't the original.
Judge
Sir,
Barr.
I can, let Ms. Luckoff go. I let you go for a while. I just want to, go ahead, Ms. Luckoff.
The date of the hearing in front of Judge Barr, they were again denied entry. This is, and there are bed bugs in the unit. And this is multifamily living. I don't have to tell the court that's not fair to the other residents. So we are asking that the judgment stand and we recover possession of the unit.
Your Honor, they called me.
Sir, what affidavit? Because I don't have,
Because
I don't have an affidavit either.
There's one from legal aid. They sent you a paperwork over. They sent you a bunch of paperwork over.
Who did?
In legal aid.
Sent me?
Yes. Yes. That's who I received my, that I was supposed to see you about.
Sir, hold on a moment. The only thing that I've received that I have in the court file, the only thing that I've received was the motion to set aside default supplement. And that's the document that's signed.
I have all the paperwork in my briefcase that I can show you.
Okay, but sir, did you let the treatment providers in?
They were told.
That's a yes or no.
Yes.
When
Not,
you let them,
not at the time that they actually came the first 2 times when we were in court. Excuse me, Your Honor, but it's important that this is clarified. On the 2nd, they were denied entry, and then on the court hearing date, which would have been the 16th, they were denied entry.
I
So
never denied
after the
them
fact,
entry.
after the judgment was entered, they were permitted entry. Because
So they were
under the
denied-
allegation,
sir, they were denied entry on the 2nd and the 16th,
correct.
or the, yeah, the
And that's the
16th.
date of the hearing was the 16th.
Incorrect.
So did they come in on the 2nd, sir?
No, they talked to my son at the office. And he told them we weren't ready at that time. He wasn't
Okay,
part of that.
that's a denial of entry.
I never denied him entry.
Well,
They never
Not-
came to my door.
if you're not ready for the treatment, that's a denial of entry.
But that was through my son, not
On the
me.
16th,
On the 16th, I told him he could come in. I told him, inspect if you want. I said, could you wait off for a couple hours? I'm at court with on Zoom with the other court.
so
with the
they
other
were,
officer,
so
with the other
hold on a
judge.
second, sir. So what I'm hearing you tell me is that on that date, the unit wasn't ready to be sprayed either.
Yes.
This is a turning point. Judge Simpson presses for clarity. Was the unit ready or not? Jack insists it was, but then admits he asked exterminators to wait. That's the crack in his defense. In eviction law, timing matters. If you delay treatment, even for personal reasons, like being in another court hearing, it can be interpreted as a denial of entry. The landlord seizes on this. They argue that even partial delays risk spreading bedbugs throughout the building. From a legal standpoint, this is powerful. The judge isn't just weighing Jack's inconvenience, but the rights of dozens of other tenants. And here's where audience comes in. Would you side with the tenant's right to prepare his unit properly, or the landlord's duty to protect the entire community?
It was ready to be sprayed. We
Then-
just had
then
to.
why were you asking them to wait?
Just because I was in court at that time. And they never gave me no warning that he was showing up or coming. It's supposed to take 24 hours notice. I didn't get no notice. They just popped in the door. I had to go to court on Zoom with the other judge. I was there. I did not deny them entry. I told them, yes, if you want to come in and inspect, come on, inspect. I said, but can you wait until a couple of hours to spray till I'm done with court? They don't give me no time. They want to do it when they want to do it.
Right.
They want to just
Exactly, sir. Exactly, sir. They needed to come in and do the treatment.
But they don't understand that we have a house we have to maintain ourselves. And when I'm on court, on Zoom, on the phone, all I'm asking for, I'll move out. I just need more time.
That's what he
That's
said
what
2
they
weeks
want.
ago.
They want me to move out. I'll move out. I just need more time to do it. Because see, the assistant manager, I don't know if this lawyer knows it or not, but they called.
When are you going to move?
I don't know yet.
Okay, let me put it to you real straightforward. I've listened to what you told me. I've looked at everything in the file, and both of those 2 times would be considered a denial of entry for treatment of the premises.
Here, Judge Simpson delivers the first major blow. He rules that both incidents, even if Jack didn't mean to deny entry, legally qualify as denials. That's devastating for Jack's case. Why? Because intent doesn't matter here. Courts focus on outcome. Were professionals able to enter and treat the unit? Yes or no? If not, the judgment often goes to the landlord. Jack, visibly shaken, pleads for fairness, arguing he never truly denied anyone. But the judge is clear, excuses won't change the fact that treatment was delayed twice. This is the moment where many viewers may feel sympathy. Jack is older, on Section 8, and losing housing could mean disaster, but sympathy doesn't always align with the law. Do you think the judge should have allowed more leniency, or was this decision inevitable?
But yeah, they didn't even start with the bed bugs at all.
Sir, if you can argue with me all you want. I'm telling you what I'm finding.
Well, do I have a right to get a lawyer or go to trial with this? Because this ain't right. This is not right. I've been haunted by this company for maintenance. The first maintenance problem started years ago.
Sir, I'm explaining to you what my finding is. Now, if you want, you have a lot of opportunities to do what you want to do. I don't have a problem with that. All right. I'm explaining to you what my findings are. Understood? Is that a yes?
Yes. Yes.
So what I'm trying to find in that the Judge Barr found that they were entitled to that, the writ should be signed. You have indicated to me that you will move, but that you needed time. So my question to you is, how much time did you need to move?
At least till like June.
Well, that's not going to happen.
Okay, because what it is Wendy, their assistant manager, called me last night at 7 o'clock and told me the lawyer told them they were coming in to exterminate today. I told him, yeah. I said, I'm not going to be there. I'm going to be at court. But they have access to come in and spray. And I'm asking, why would they do that if they're going to want us out anyways? They're
Because the problem that's causes problems for all of the other residents. If your unit doesn't get exterminated, everybody else in that building has a problem. That's why.
Right. I understand that. I understand that.
At this stage, the judge is laser focused on the bigger picture, infestation risks in multi-unit housing. Even if Jack insists he was self-treating with store-bought sprays and planning to toss out his couch, the law doesn't allow tenants to handle infestations entirely on their own terms. Bed bugs spread fast, and untreated units can force every neighbor into the same nightmare. Notice how Judge Simpson frames it. The landlord has a responsibility to protect all residents, not just one. This is a common theme in housing law. The rights of the community often outweigh the rights of the individual tenant when health is on the line. But Jack's counter-argument is emotional. He's lived there for years, paid rent faithfully, and feels singled out. Viewers, ask yourself, does his long tenancy and payment history earn him more patience, or do the health risks justify immediate eviction?
I've been self-exterminating myself before they ever showed up. I was self-exterminating with Orthex or whatever it is. I paid $20 a gallon for it. It just didn't totally eliminate it. And I know what the problem is. I have to get rid of my couch. My couch is a major problem with them. And I'm getting rid of the couch this month. I needed money to buy another couch. And that's a major problem. It's right there. They're all in the couch. There's nowhere else in the house that they're accumulating that, just in there. And the other problem is the people that moved out before me in the building across the hall, they moved out 3 months before Arbor One discovered they moved, and they had to remove their couch and love seat because they left it behind.
Okay. All of that's fine. The problem is that the landlord, you objected when you came in here to the hearing that took place before Judge Barr. That's what you were giving me, which is the only reason that I set this where I did. The problem here is that there was a denial of entry to the premises.
But that one you're not on the court docket.
It just is. It is what it is, sir.
But Your Honor, what I'm trying to say though is through the original judgment, it was over garbage bags. It wasn't over bed bugs. And they said we didn't prep for the bed bugs the first time. When they gave the court order, they never gave me a prep sheet. They never told me. They said, oh, go back to your prep sheet in December. We never got the prep sheet in December at all. They started this in January, and they said, go back to your prep sheet you got in December to prep it. Well, I never got no prep sheet on bed bugs. We get a prep sheet on cockroaches, which is total different prep. It's a total different prep for cockroaches and bed bugs. We never received a prep sheet for bed bugs, so we didn't know what to prep.
Jack introduces a new angle here, procedural fairness. He claims he never got a prep sheet for bed bug treatment, only one for cockroaches. That's significant because in many jurisdictions, landlords must provide clear prep instructions before treatments. Without them, tenants can argue they weren't properly notified of what was expected. But here's the danger in Jack's approach. He keeps bringing up new defenses late in the process. Judges hate that. Simpson calls it out directly. Every time Jack hears a ruling, he introduces a new excuse. It looks less like a legal defense and more like stalling. This tension builds the drama. Is Jack a victim of sloppy landlord communication, or is he grasping at straws to avoid accountability? Let me know what you think. Is lack of a prep sheet enough to excuse 2 denied entries?
So how can I bring him in and say, yeah, we'll prep when I don't have a prep sheet to know how to prep it? or what they want for prep. And even the exterminator came in there and I asked him, are you doing bed bugs and cockroaches? He said, no. He said, I didn't even get a work order on bed bugs. They didn't even get a work order on it.
Your Honor,
Sir,
you want
let
me
me
to
just
stop?
say this. Every time I tell you what I'm finding, you keep telling me something new. It doesn't work that way.
But you're going to
I'm
only
dealing-
2 times, Your Honor. They're going to, you're only going to 2 times.
You can keep interrupting me all you want.
I'm sorry. I'm sorry.
It's not going to change my decision.
I'm sorry. It's just,
There was a hearing that was held on this. The hearing, I don't find a defect in the hearing. I don't find a defect in the hearing. The judgment will stand. The writ will issue.
how long?
I'm done. The writ issues. It's the statutory. There's no period, sir. There was a hearing that was held.
Well, how long do I have to move? I'm saying, how long are they going to give me time?
I've just signed the writ, sir. So you're operating on borrowed time.
Well, because I'm going to lose my Section 8. If this writ goes through, I lose my Section 8. And I have no other way of paying my rent or anything. I've been there 6.5 years. Paid my rent, never gave a problem at all to them. And because of bed bugs they're supposed to eliminate, I'm being accused of something I didn't even do. I haven't even done anything that is causes warrant for me to be evicted. That's why I'm asking. I just need a little more time, yeah. You know, I need at least a month. And now, if they're causing on a writ, that means they're evicting me. No place is going to touch me with an eviction. You understand what I'm saying? I go to some place, tell them, oh, I got evicted. I'm hit. I'm 60 years old. I don't have time for that. I was trying to retire. I told them up front, I would work with them on stuff. I said, no problem. I'll work with you. We got to work with it, work with it. Yeah, I don't know what else to say. I was never given a lawyer. I have to sit here and defend a lawyer when I don't have that kind of smarts. You know, I'm not that smart to deal with a lawyer. You know, and I'm not even given a chance for a...
Sir, do not come before me and tell me that as a tenant, you're not given a chance, not before me, because that doesn't happen before me.
Your Honor, I called a lawyer. They said they didn't have a lawyer for me.
Sir, you have interrupted me constantly through these proceedings.
I'm sorry.
Now are intending.
I apologize.
No, do not interrupt me again. You now want to insult me by saying that somehow or another you don't get a fair hearing when you came here. When you came here the first time, I told you what I would do. I read your motion. I went through everything to see whether or not there had been something, because you claimed a number of defects. I then bring you back here, have treated you fairly, have listened to everything you have said. And how dare you say to this court that somehow and or another you don't get a fair hearing for me?
Here's where the courtroom explodes. Judge Simpson's patience finally snaps. After listening to Jack's constant interruptions and accusations of unfairness, the judge erupts with one of the strongest rebukes you'll ever hear in housing court. How dare you say you don't get a fair hearing from me? That line carries weight. It's not just about Jack, it's about protecting the integrity of the court. Judges take accusations of bias very seriously, and when a litigant implies the system is stacked against them, it cuts deep. The drama is at its peak. Jack, a desperate tenant fearing eviction and the loss of Section 8, versus a judge asserting authority and courtroom order. For you watching, do you think the judge went too far here, or was this firm correction exactly what was needed to keep control?
I've made my ruling. I'm done. Thank you.
Still feel like my rights were violated.
I'd suggest that you close your mouth as you leave, because otherwise you're going to be going with my bailiff.
Steps out.
Arbor,
The gavel may not have literally slammed, but Judge Simpson's closing words carried the same finality. The ruling stood. The writ of eviction would issue. For Jack, the consequences are life-changing, losing not only his unit but also his Section 8 voucher, which could mean homelessness at 60 years old. From a legal perspective, the case reinforces two key takeaways. Tenant access matters. Even unintentional delays count as denial of entry. Courtroom conduct matters. Interruptions, shifting defenses, and challenging the judge's fairness can backfire. Yet, emotionally, this case highlights the brutal reality of housing law. How quickly decades of tenancy can collapse under procedural missteps. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your engagement helps us bring more of these real legal dramas straight to you.